Welcome back. Now, a parliamentary probe into government's Karpowership deal has been scrapped. It follows the High Court in Pretoria's dismissal of a legal bid challenging the award of the contract. The court found that the rival provider that brought the application did not meet the requirements. ANC members on the Energy Committee voted to can the inquiry as a court had already ruled on the matter, but opposition parties say the inquiry would have had a wider scope than the court application. Let's discuss this further now with the committee chairperson and ANC MP, Sahlulele Luzipo. Thank you very much, Mr. Luzipo, for your time here on All Angles. Now, of course, this, I believe, was because you got legal advice from Parliament's legal team to say you should let this go because of that court ruling.
Yes, good morning to you, if you was at home. Look, I think it's exactly that. The latter part is not necessarily that the probe again, the vote which we had to go to was based on the probe, was based on the investigative inquiry. It was based on the legal advice, on the basis that obviously, and I think it's incorrect to suggest that the court did not. The court, by the way, because the application was challenging the very same process, that the process was flawed, it was not above board, and it was on those bases that the court made a ruling and said, even though there would have been attempts, including trying to coerce or manipulate the process, the manner in which the process was, it was impossible that it could be easily or it could be manipulated at all. So you will recall then that the basis of the inquiry was also reliant on the court, which is why we asked the committee, asked the legal services to advise it whether a committee of parliament can deal with a matter which is in front of a court. And the advice was simple: any matter the committee can deal with it, even those that are in front of the court. But the issue now is that the court is the only legal authority that can make, and in this case it has made, factual and legal finding. And therefore there was the legal advice was that there was no basis to continue with this exercise. And I must say there's a precedent-setting exercise. When the Zondo Commission started its work, all committees of parliament were told that they must cease to deal with any inquiry that they were dealing with because there was a judicial process. And therefore, the determination of any legal or constitutional matter only rests with the authority of the judiciary. And that's exactly what committee members felt we needed to respect.
So this application to the court was brought by one person who was a rival applicant of that particular tender, and even though they found it to be wrong for that one particular company, there were many others who were bidding. So don't you think where there's smoke, there's fire, and that the investigations should still continue?
The question is on what? Because, as I'm saying, the court did not only deal with the grievance, it dealt with the process. And the court, in its judgment, said the process was above board, it was impossible that it could have been corrupted. And I must also correct this thing. The matter is not about Karpowership. The matter is about the process of procurement in relation to the risk mitigating independent power producer procurement. And therefore, the question of then who then is not the only company that was granted the right to proceed to the next phase. So when the court made the ruling, it did not make a ruling whether this company, only this company had the capacity or was treated unfairly. It also dealt with the process of the risk mitigating independent power producer procurement. And on those bases, that was the reason, by the way, the committee had to rescind its initial decision, because that company had gone to court and said it's challenging the legality and the genuineness of the process that the department had and that department has gone on. And therefore, on those bases, the matter came back to the committee. A ruling is sitting of the court. Now, the question, and I think I must correct also, there's one perception that is being created, Some people say, yes, it's fine, the court has made a ruling on the process and the legality of it. But what then they argue is that the terms of reference were not all addressed by the court judgment. The matter is simple. When you rescind a decision, you don't rescind a decision with terms of reference. Terms of reference comes as a consequence that you have taken a particular decision. And that is why at all material times, your terms of reference can change depending on what you are looking for. And at this stage, for instance, there is nothing that says the committee has abdicated its responsibility to conduct oversight. The issue here is that the committee is seized with a responsibility to conduct its oversight over the executive authority on its executive actions. And it can be only reduced on an inquiry or an investigating inquiry. And worst of all, you can't suggest that as members of parliament, you've got no duty and responsibility even to conduct that investigation. Hence, you will ask for external powers in the form of an evidence leader. The rules of parliament are clear. It is members of parliament that must be seized with the responsibility to conduct oversight. How that oversight you conduct it is not prescribed that it can only take place if you go through an inquiry. And I think that issue is up front for everyone to see it. Lastly, we cannot pretend as if you ask for legal advice and then you say, no. You ask for a legal advice because you are not an expert in that field. And therefore, on the basis that we are given a professional advice, you have to respect it because you still have to follow that process, even if you were to go the route that some members were suggesting. The question is, if those people tell you, no, but we told you what you are going for is a fishing expedition, and on our side, we don't think that we can be able to help you, what then do you do going forward?
All right, Committee Chairperson and ANC MP Sahlulele Luzipo, thank you very much for that clarity. Of course, Parliament deciding that it will rescind the decision to actually investigate the risk mitigation independent power producer procurement program because the High Court actually exonerated the department for how it went about that tender. Let's go to this.